Thanks for staying with us. You're still watching Standpoint. Now, INEC on Sunday, July the 17th, declared PDP candidate Adeleke as the winner of the Osun State governorship election. But the Osun Tribunal annulled the election of Adeleke and declared Oyetola as winner. Justice Tese Kume, while delivering a majority decision, declared that the Independent National Electoral Commission, that's INEC, did not comply substantially with the Constitution and the provisions of the Electoral Act. Now, in a twist, the Court of Appeal, however, on Friday annulled the tribunal's decision and upheld Adeleke as the rightful governor of Osun State in a unanimous decision by a three-man panel headed by Justice Mohammed Shuaibu. The appellate court also upheld the issue of beavers raised against Oyetola, stating that the Osun State Tribunal was wrong to have said that there was overvoting, a claim that only relied on the evidence provided by Oyetola and the APC, and as such doesn't prove their case in any way. And joining me now to talk about this is a lawyer, Evans Ofeli. He joins me in the studio. Good to have you join us.
Thank you. Good afternoon.
This is perhaps if not one of the biggest stories in the country today. It was a week of, a lot of stories, and most of them have to do with the judiciary.
Yes.
But let's talk about this particular one. What do you make of this particular judgment coming from this appeal court?
Yeah, earlier on, the tribunal had ruled that INEC was wrong to have declared Adeleke the winner of that election because the APC had gone to court and have challenged the position of INEC. And one of the issues they raised was the issue of jurisdiction, and the other was the issue of overvoting. Now, on the issue of jurisdiction, the Court of Appeal, have just rested that on the ground that by Section 858, 8 of the 1999 Constitution, once a political party or a candidate raises issues of jurisdiction, the court will have to suspend the issue of jurisdiction and take it during the judgment, substantive judgment, which is actually what happened in this case. And that went in the favor of Adeleke. Then the second issue that has to do with overvoting, the overvoting that the APC alleged were evidence that they adduced to the courts using the back-end result of the beavers without considering the voters' register. So when you look at the voters' register and you look at what you have in the beavers, you have discrepancy. For the Court of Appeal was of the view that the evidence they procured, APC procured the evidence that seems to them without considering the voter register. And so same was resolved in favor of Adeleke. And so the decision of the tribunal was annulled. This is unanimously. At the level of the tribunal, we had 2-1, a panel of 3, 2, give judgment in favor of Oyetola, 1 dissented. But right now, at the Court of Appeal, the 3 justices at the panel all give judgment in favor of Adeleke. So right now, the Supreme Court is the next phase for which parties will have to, submit their argument accordingly to the Supreme Court. The Supreme Court will decide whether or not it was Adeleke that won the election or Oyetola.
So you just mentioned one of the probably the confusing part for a lot of people, where the judge faulted Oyetola and the APC that they only relied on the data from the back-end server and failed to look at the voters' register, which forms the foundation of the whole electoral process, and as such cannot strengthen the allegations of overvoting. But a lot of people will say, look, when politicians allege that there was irregularity in elections, the first thing they ask to see is the back-end server, the beavers and the back-end server. And we've seen it even playing out in this particular election. It's almost as though the court is saying, that is not evidence from the back-end server is not sufficient.
Yeah, because that is not the only evidence there is. You see, when we get to tribunal, what parties or the litigants are doing in tribunal is that you are contesting that there's substantial non-compliance with the Electoral Act. Okay, that's the first thing you need to prove, that there's substantial non-compliance with the Electoral Act. Then two, you have to also prove how the said substantial non-compliance with the Electoral Act affected the outcome. So it's not enough to say because there's a presumption of regularity. There's a presumption of law that every election was well conducted by INEC. There's a presumption. So for you to rebut that presumption, you are doing it against the backdrop that you have sufficient evidence to unseat that decision, to prove. If the evidence you have only proved that there were irregularities, you have not proven your case. The evidence must go further to prove that this same irregularity that I allege affected the outcome. Because ordinarily, there's regularity. So the court will only move. The hands of the court will be moved where the irregularities now affect the outcome. And that's what they're saying here, that you have evidence at a back-end server evidencing overvoting, okay? Now, that evidence is what you adduced. The fundamental evidence, the voter register, which is actually a practical exhibition of what transpired at the polling units, which is a clear evidence to both electors and the contestants, were not considered. And you see, the reason why that was not considered by the AP is because if you come before a court with divergent evidence, one saying this and the other one saying that, the rule of law, the rule in evidence is that both of them will not pass. You understand? So, I mean, they must have looked at the voter register and then look at the back end and the discrepancies.
I wouldn't want us to speak on speculation because one wasn't there when, you know, they were deciding on the evidence.
No, it's not speculation. I'm just saying the rule of law that if you have two divergent evidence trying to prove something, the two will not be considered.
Both of them are cancelled.
Yes, that's what I'm saying. They are divergent.
All right. So let's talk about this particular judgment. The APC and Oyetola might end up at the Supreme Court. But however this case ends, whatever judgment the Supreme Court is likely to give, if they do decide to take the case to the Supreme Court, do you think that could become a precedent in terms of for some of the litigation we're going to see arising from this general election at all levels?
Of course. You know that this Osun election was one of the elections that the Beavers was deployed. Okay, so it's going to be like a pioneer precedent looking at the Beavers. We already have precedents in election matters, enough of it, plethora of evidence, but the one that really touched on the Beavers.
Because this is the first time we're legally employing technology in an election.
Yes. No, we've employed technology before when we had card readers. When I say legally,
the first time they're saying, look, because in a card reader case, there were cases in court where the judge would say, they cannot accept the evidence from the court reader, the card reader. But this is the first time where, you know, technological evidence has now been accepted in court.
Yes, being accepted. And that is why there was a public outcry, you know, during the just concluded election that you should upload to the Beavers and all that. People were saying all that. But, you know, the truth is that this judgment, the coming judgment, that's if the case goes to the Supreme Court, is most likely going to go to the Supreme Court, will go a long way to influence the decisions that, because a lot of politicians are in the tribunal now, so to speak, in virtually all the states and the local, even the presidential, they are all in court right now. So this is going to be the pioneer precedent that it will go a long way because it touches on the Beavers and it touches on the new Electoral Act. Remember, that election was conducted based on the new Electoral Act. So, and the new Electoral Act is actually a shift away from what we had before, because now you have a lot of innovations. Before, if anybody can go to court to contest the qualification or otherwise of a candidate, before now, the law just said that get the form, look at it, and file your case and come up with evidence to prove. But today, you must be a candidate. You must have contested before you can. So it has been shrunk. Okay, unlike before, anybody can just wake up and go. Now you have a lot of innovations too there. Okay, so we'll look at it, we'll watch it and see how this is going to turn out. But it's going to be a time where our jurisprudence will be enriched because the judges will be working on. You see, the best person and the party that comply with the Electoral Act and the conduct of INEC will go a long way to influence. Of course, in all these cases, INEC is a party because they are the umpire. They conducted the election. So everyone going to court will drag INEC along. And INEC must also go to prove its case based on the Electoral Act.
Perhaps why a lot of people are worried about the influence of the judiciary in an election. Because you look at the fact that since last year when this election was held in Osun State,
yes.
It still has not been concluded.
Yes.
Election was held in 2022.
Yes.
In 2023, we're still talking about that particular election.
Yes.
And people are wondering, why do we have to go through that? Because again, some people will say it does have an impact on governance in that state or in that country, where you have to wait for the decision of the Supreme Court or whatever level they decide to stop, yes, to decide who is the legal winner, yes, of that particular election.
Yes, it's true, because you see, you can't just conduct election and then ask everybody to go to bed, especially when there are irregularities. They have to go to court. The law is that the tribunal have 180 days within which to determine the case at the tribunal level. And when it gets on appeal, the Court of Appeal have 60 days within which to do that, and that of the Supreme Court. So that window must be, because the truth is that it's a journey to find justice. You see, because if a party is not well treated by virtue of the way the election is conducted, it's not just the candidate. He has supporters who are not also happy, okay? So for whatever they have done during the process. So if you say, if we want to all agree and say, okay, no, because election petition takes a lot of time, it drags, it affects governance, therefore we should just say, you're going to have a lot of issues in society. But when the court steps in and they're able to submit their grievances to the court is able to come up with decisions, with reasons, and those reasons seems to...
When you say, because I don't want us to move past that, when you say it's about justice,
yes,
can we say that justice has been done? Because the court will only rule based on the evidence before it.
Yes.
And it doesn't matter if you really feel that there were irregularities. If you cannot prove your case, the judge is not going to say, because, let me have pity on you.
No, there's
go
nothing,
with you.
there's
so
nothing like...
There's not like pity. So you were talking about justice being done, because it's really about the evidence you bring to court.
Yeah, the justice
not
I'm
necessarily
referring to,
about justice itself.
The justice I'm referring to is tied to your ability to prove your case. It's not. There are cases where the justices have sat down, looked at the case. They know that the case should have gone this way, but for lack of evidence. Justice Kayode Esho of blessed memory, there was a particular criminal case that he delivered judgment. He said it in his judgment that this case looks up to the high heavens for want of evidence. And they have to rule the other way. Because they cannot, the court will not help you to produce evidence to help you win your case. That's not the duty of the court. It is the law that the court must not step into the arena of conflict. The court must be an umpire, watch, adduce your evidence, adduce it, they put it on the preponderance of evidence. So by that, the court will now make a decision based on the scale of justice, which area, which party has adduced enough evidence, and where is the scale of justice weighing, how is the weight of the scale of justice. That will determine what will happen. And then that is what, there's no settlement, nothing attached to, and they have nothing to lose or gain based on the case before them. They are just going to do a dispassionate assessment of the case and give judgment accordingly.
And we've also seen not conflicting, but different judgments, because at the tribunal level it was different.
Yes.
Oyetola was upheld as winner.
Yes.
But in the appeal, it's also different.
Yes.
It's now back to Adeleke.
Yes.
One knows, only God knows who will be declared.
Time will tell.
At the Supreme Court. It also means that interpretation of the law is subject to the person who, or the judge who is going through the evidence, because we see that at the tribunal, it was fine with, the tribunal said you were able to prove overvoting. But at the Court of Appeal, they're saying you were not able to prove overvoting.
Yes, they're saying you're not, because the court will need to avert its mind. That is why we have options of appeal. Okay, if the court of first instance, the tribunal in this case, did not avert its mind to a particular angle, and then the court of appeal came and entrenched it, sometimes even the court of appeal may be wrong. Because when you get to the Supreme Court may pronounce the court of appeal wrong and say the court of first instance actually got it right. We've seen that. We've seen cases where the court of first instance will be pronounced wrong, the Court of Appeal will pronounce wrong, and the Supreme Court will upon the decision of both courts. So it's neither here nor there. So the issue is that the parties must just submit to the authority of the judiciary to determine. Unfortunately, that is what we now have in our society. It's supposed to be the electors that should decide who will govern them. But it appears that because our electoral system, whether it has not grown, I don't know, or whether INEC is not doing the proper thing or they are doing the proper thing, most times it's the judiciary that now determines.
And besides, I think whether we grow or not, politicians will be politicians. When people are always going to feel aggrieved and go to court. But just finally, maybe in just a minute, many will also speak to the speed, as it were, of this particular case, because whilst he was declared winner in July, the tribunal case at the tribunal just started not quite long ago, and then we'll see it in the Court of Appeal, and perhaps maybe soon we'll see it in Supreme Court if they do decide to go there. Do you think that really for every other case in the country, because cases really do drag, that look, there should be also a time limit so that we can deal with these issues and get them out of court? There
should. Do you know, in the past, there was no time limit for even an electoral matter. That's when you have someone who will be sworn in as governor after almost 3 years, almost completing his tenure. The court will rule that. That's why we have staggered elections. Is that so? The legislature looked at it and now, okay, let's have a time limit, 180 days, 60 to conclude. You understand? And that should apply to them, because we have criminal cases that have been in court. We have land matters that have been in court for years. There's a land matter I concluded that was filed in 1974. I was not born when it was filed. I concluded it. So you have all that in our courts. So maybe we should also have time limits. But the most important is that we must expand the courts and have more judges, because we have few hands. The cases are much. The whole place is overcast. Sometimes you come to court in the morning, you see the cost list, you have 44 cases, one judge, sometimes 51 person. Wow. So it's so much in our system.
Lawyer, you know, when you said in 1974 you were not born, my mind started calculating your age, but I'll do that after the show. Thank you so much for talking to us, Lawyer Evans Ofeli. And that's Standpoint today. Remember, you can watch a repeat. There's a repeat at 11 p.m. tonight and 5 a.m. on Sunday morning. I am Precious Amayo. Thanks for watching.